You are back within session. Glad to have you here. Closing arguments in the Stephen Hayes murder trial are set to begin in less than an hour now. Stephen Hayes on trial for the killing of Jennifer Hawk Pettit and her daughters, Michaela and Haley. Criminal defense attorney following this thing closely. He used to clerk for Judge Jon Blue, the judge presiding over this trial, and Murray joins us now from outside the courthouse in New Haven. Thank you so much, Mr. Murray, for being with us. You know, we've learned so much
Thank you for having me.
Sure. We've learned so much about the victims in this case and the defendants that are on trial, but what about the man presiding over it all? I understand you described Judge Blue at one point as saying he belongs in a Dickens novel. What did you mean by that?
Judge Blue is a true legal scholar. He cares very much about the law. He cares very much about procedure and decorum. I know other attorneys have used the word quirky to describe his personality. And, you know, from the bench and in discussions with him, he does come across as a man from another era. He's very literary. Again, none of this is said disparagingly. He's a wonderful judge. He's a true legal intellect, a true legal scholar. But his mannerisms and his demeanor kind of remind you of someone from another time.
Very interesting. Now, what about the two attorneys in this case? Because as I understand it, this is a death penalty case, so not all attorneys, do we say, qualify for a case like this. What can you tell us about both of them?
Now, there is a death penalty certification in the state of Connecticut, as I understand it. I personally don't have one. But Tom Ullmann and Mike Dearington have both done death penalty cases before. They did the Jonathan Mills case in 2004, which Judge Blue presided over and for which I was also the clerk. Tom Ullmann genuinely cares about the defendants, and I think he is genuinely sympathetic towards the victims as well. He's a very sympathetic individual. He is very novel in his approach to case law. He's very innovative, and in the Jonathan Mills case, he actually filed a motion trying to assert that the defendant, not that the defendant had a right to counsel, but that he as counsel had a right to that particular defendant. And it arose out of the circumstances of the case. Judge Blue ultimately ruled against that, but he's very good at finding these interesting little bits of legal minutia that he can use to try to help his clients. And in that case, he was trying to suppress Jonathan Mills' confession by saying he should have had counsel present. Mike Dearington is very logical, very methodical. He's not given to hyperbole. He's not given to sensationalism. He puts on a very clean trial, very straightforward trial, very fact-based.
Let's talk about the attorney for Joshua Komisarjevsky, who is the co-defendant here. I know his trial comes up a little bit later next year. But he defied a gag order at one point that the judge had imposed here on this. It upset a lot of people, I understand. You know, he went to the microphone, talked about Komisarjevsky's role in this whole thing. How do you think the judge in that case is going to handle that, basically, defiance of the gag order?
Yeah, Judge Fasano is, I believe at the moment, he was in the past the presiding judge for criminal in New Haven, and I believe he is now. He's the one who's going to be handling this motion. My guess is because Judge Blue is going to be handling the trial for Komisarjevsky, Sullivan's going to be the attorney, they don't want Judge Blue ruling on the gag order for this particular instance.
Gotcha.
I know that this gag order has been a bone of contention for the last number of years, almost since the inception of this case. You know, I read through the New Haven Register accounts. I have no personal insight into Sullivan. I don't know him as an attorney or as a person. But in reading the New Haven Register accounts of his little speech from the steps of the courthouse last Friday, I found it to be internally inconsistent. At one point he says he's doing this to try to give the family some closure by saying that the particular sexual assault that was alleged by the evidence at trial is not what happened. But he also said that he didn't think that what he was saying was violating the gag order. But then in addition to that, he said doing this is the only way to get the gag order back in front of the judge to appeal it. So I'm not sure what he was trying to do. If he was really trying to allay some of the family's concerns about what happened, he could have done that back channel without going in front of the cameras.
In front of the cameras, yeah.
I'm still trying to wrap my brain around what he was trying to accomplish by doing that, given the possible sanctions he faces by doing that.
Right, right. And one last question for you. When do you think we're going to have a verdict? How long do you think it's going to take?
Well, I know they're doing closing arguments today, and it's not unusual in a case of this kind for the judge to entertain a request to extend closing arguments from an hour to an hour and a half. In terms of the technology I know you spoke of before, the state has in the past used PowerPoint presentations projected on a screen for the jury. They also have a device that you can place a document on, and it magnifies and projects an image of a document on the screen to the jury. Of course, they're going to put up pictures of the family and pictures of the evidence. In terms of the charge to the jury on Monday, it's probably going to be about 30 to 50 pages long, double-spaced. It's going to take a couple hours. The judge is going to address the law. He's going to address the jury's responsibilities. He's going to address the rules of evidence. So if they get that started first thing in the morning, theoretically, if it takes 2 hours, the jury will probably go to lunch and then come back and start deliberations. Given the evidence in this case, they're probably going to come back very quickly. I have found in the past a lot of juries, I also sat for the Pettit murder trial, which was a big deal here in New Haven. Juries, even if they take that first vote and they're unanimous and it's 12-0, a lot of times juries will rise to the occasion, and just to be sure and make sure they're of the same mind, they will go through the evidence piece by piece very methodically. I've walked in there and seen grids up on the chalkboard in the jury room where they've actually literally spelled out each charge, and they've put little check boxes that the state proved their burden. So, they could come back in 20 minutes if they're all of the same mind, but I have a feeling that they'll probably want to go through the evidence to some degree just to make sure that they're all on the same page.
Sure. All right. Criminal defense attorney Keith Murray, thank you for your insight, walking us through all of this. We appreciate it very much.
Thank you.
Right now we're taking your calls. With me to help is criminal defense attorney and former FBI analyst Keith Murray, and in session law enforcement contributor Mike Brooks. And, before we start, I want to ask Keith a question. Keith, first of all, good to see you. And you were once a clerk, as I understand it, for Judge Blue. What's he like, and what do you think he's like with these kinds of cases, especially this one, since it is so important to the state of Connecticut?
I did clerk for Judge Blue for 3.5 years. It was my day job while I went to law school at night. He's, as I've said before, he's very much about propriety and decorum in the courtroom. He's very much a legal intellect. He's brilliant in his field. He does the Supreme Court roundup every year for the Judges Institute here in Connecticut. The judges get together for a series of seminars, and he researches and writes up briefs on all of the court opinions that have come down throughout the course of the year. There's a reason why Judge Blue and Tom Ullmann and Mike Dearington are the individuals chosen to conduct a trial like this. They're all at the top of their fields. They're all extremely good at what they do. And they've done this before. This isn't the first capital case that the three of them have done together.
The Mills case being the other case, a case that
yes,
was in some ways just very violent as well and very horrifying to see.
Yes, I actually sat as clerk for that case, and that was another instance where we had a good few months of jury selection. The evidence was horrific. I remember during jury selection they were debating whether or not to show potential jurors some of the crime scene photos. And if you recall, it was a mother and their 2 children were stabbed to death in their bed as they slept 2 days after Christmas. I think they were stabbed like 53 times. And the evidence photos are horrific. I mean, it's the 2 kids in their pajamas and the mother, and there's a lot of blood.
Unbelievable.
And
very similar to this case,
that.
Keith. I can understand how similar that is. I'm sorry to interrupt you. I want to just make sure we get to our call. I think Alicia brings up a good point, as does Mike. You got to assess the situation. Do you think when you look at this that the police handled this correctly, or should they have had another way to move faster?
No, the police have protocols and procedures that are in place specifically for situations like this. They train on these issues in hostage situations. You establish the perimeter. You try to gain what intelligence you can without inciting a situation further. And that does take time. And when this thing went down, when that match was dropped, it went very quickly. The police had very little time to respond. And, police officers did try to run into the house when they first saw that there were flames and there was smoke, and they were stopped. The flames were so intense because the defendants allegedly threw down gasoline all over the house in pools and in trails to ignite this thing as quickly as possible. But like I said, they have procedures and protocols in place. I think that the police followed them, and they exist to safeguard the lives of the people in the house and to try to allow the police to get the perpetrators out of there alive and in custody. And I think the police, probably followed what procedures and protocols that they usually would rely on in a situation like this.
All right, Keith Murray, Mike Brooks, thank you so much.